Hi, today we're talking about how you prepare your civil case for trial. Once a civil case has been set down or prepared for trial, the court will then arrange for something called the pre-trial conference, and this is to find out the status of the case and also to schedule the dates for the actual trial. When you attend this pre-trial conference, you should come prepared to take the trial dates and to inform the judge of the number of witnesses you would like to call, as well as the estimated number of days that you think the trial will take. You should check with your witnesses before this to make sure that they are available, of course. The trial will generally be fixed within a month or 28 days from the date of the pre-trial conference. If you or any of your witnesses cannot speak English, you must inform the judge at the pre-trial conference. You must also make sure that all your witnesses will be able to attend the trial. If you are not sure whether your witnesses will attend the trial, you should apply for a court order. This is called a subpoena, to force or to compel them to attend at the trial. Once this subpoena is issued to a person, he must attend court on the stipulated date and time. And if he fails to attend court, he will be guilty of contempt of court, and he may then be punished with a fine or even imprisonment. Parties must submit trial documents at least 5 days before the start of the trial. These include things such as the affidavits of evidence in chief and the bundle of documents. An affidavit is a document that contains facts that you have to swear under oath or affirm are true and correct. In civil cases, you can use an affidavit instead of giving evidence to the judge as a witness, and each person must submit to the court the originals of the affidavit of evidence in chief of all their witnesses, as well as a bundle of the main documents that will be used or referred to at the trial by him. As far as possible, a common bundle of core documents should be agreed on between both parties and then filed by the plaintiff. Something called the opening statements needs also to be filed, and the opening statements are required in cases except where the trial judge has dispensed with this requirement, such as in motor vehicle accidents. The opening statements should state the person's case in a nutshell, both in terms of the facts as well as the law. You'll also need to file something called the bundle of authorities. To improve the conduct of civil proceedings and to reduce the time taken in the presentation of cases in court, parties are also required to prepare a bundle of the legal cases and authorities which should accompany the opening statement. The legal authorities includes things such as statutes, written law, regulations that you're relying on, and of course legal cases and reference materials that you're relying on. Besides submitting these documents, the documents should also be served on the other side, the other party involved in the case, and the detailed contents and format of the submission of these documents can be found in the rules relating to trials. This is called the State Courts or the Supreme Court Practice Directions. So there you have it, some very basic information on how you prepare your civil case when it proceeds to a trial. Thanks for watching. Bye-bye.